Okay, so I'm going to take us back because my research looks at obligations, kind of like Julia's, and I focus on international law and the way it contributes to efforts to adapt to climate change, including efforts to facilitate and address migration before people are forced to move. Okay, so I'm increasingly interested in building on this to understand the relationship between adaptation and reparative demands, and kind of the tensions and the shared aims and the role migration might play in both discussions of adaptation and reparations. All right. So to that end, I'm going to use my time today to explore three things. First, the suggestion made by scholars that migration can be a form of reparation. Second, my research, which is related to migration as a form of adaptation, that also recognizes that people can and should be able to stay and not move. And then finally, to consider the alignment and tensions between arguments related to moving and staying and between adaptation and reparations more broadly. So on the first point, migration as reparation. So Carmen Gonzalez and others discuss and argue for migration as a form of climate reparation. And this work draws on historical wrongs that have been discussed already: racism, colonialism, resource expropriation, extractivism, these kinds of concepts, and then the disproportionate and historic and current contributions of the global north to the causes of climate change. These forces come together through colonial and post-colonial interventions to exacerbate vulnerability to climate impacts. And the reparative argument for migration recognizes this as a fundamental starting point to call for those displaced by climate change to be admitted to other countries that have benefited from its causes. There's also a turn towards self-determination, both as a legal norm and as something inherently moral, to argue that countries from the global north are required to take in migrants. Now, some of these arguments, which are also grounded on moral and ethical obligation, use international law to bolster their arguments. Others avoid these legal obligations because they argue, like Maxime Burkett, that law is part of the problem that needs to be confronted. So Burkett argues that law is complicit in the racialized distribution of environmental degradation and impacts, and that there are clear limits to migration governance that fail to map onto efforts for climate justice. And on many counts, I don't disagree. So my research takes these criticisms as part of the premise and as the context in which to work within. So I will take as a given that international law is not neutral, and it reflects the structures and politics in which it arose. Certain countries and communities and individuals within these countries also face an unfair, disproportionate burden of the impacts as a result of this context and this history. And this framing helps the framing of climate migration as a security risk helps shift the blame back to the individual migrant instead of to the countries and companies that contribute to its causes and their worsened adverse effects. Migration legal frameworks are also inadequate, and they leave gaps in legal protection that heighten risk for climate impacts. And I'm happy to discuss that more if there's questions around that in the Q&A. So my research starts from this context, and it focuses on a different temporal moment than most migration frameworks. So instead of an emphasis on legal protection after people move, or addressing displacement that is seen as an inevitability, it focuses on how to argue for state action in anticipation of harm, before harm causes more damage and before people are forced to move. And it does so by using international law as a tool to bolster legal and conceptual arguments for more adaptive mobility. So rather than making climate migration an issue to be governed by existing migration frameworks, it flips the approach. And these frameworks tend to focus the locus of the problem, as I've mentioned, and the solution on the individual migrant. I flipped the approach, the conceptual and legal starting point, to look at the role of climate change in international law, and to demand a more collective solution to what should be considered a collective problem. And I anchor my arguments in the climate change regime, and that includes the UNFCCC and the Paris Agreement, with a focus on obligations on adaptation in these treaties. And it's in part because these treaties enjoy near universal participation. So what that means under international law is that every state is subject to their terms, and they create binding commitments that states cannot make reservations on, in theory, to help shape climate action, including on adaptation. Adaptation is also both responsive and it's crucially, it's anticipatory. So it's not limited temporally as migration frameworks are, and it's not focused on a specific type of movement or category of migrant. And in fact, adaptation doesn't necessarily even address the issue of migration at all. But that's why it's important, because it includes a wider range of measures for state action to address climate impacts. All right, so what are these obligations, right? My research starts by identifying three types of adaptation obligations in climate treaties. And the first are obligations to act, so action by planning for and implementing adaptation. The UNFCCC, for example, requires all parties to formulate and implement programs that contain measures to facilitate adequate adaptation. And then the Paris Agreement builds and expands on this to require states not only to plan for adaptation, but as appropriate to implement adaptation obligations. The next two types of obligations are particularly important for our discussions today about Australia, as they commit Australia to provide support to vulnerable developing countries, something that Zoe's already kind of highlighted in the Q&A last time. They are obligations of assistance with an emphasis on financial and technological support to help, for example, developing country parties to meet the cost of adaptation and to require continuous and enhanced international support. And then the third form of obligation are obligations of cooperation, which really bolster these assistance obligations and operationalize them. Now, these are broad and they're couched in terms that afford states a lot of discretion. So that leaves open these questions about what their scope is, what their content is, and what their utility is. So I answer some of these questions by putting them into the broader, wider international legal system. And I argue, and I'll do this through two general interpretive arguments. The first argument is that international human rights law should be incorporated into the interpretation of adaptation obligations, and in particular, the inclusion of positive duties that require states to protect human rights, right? So this accords with the tools of treaty interpretation, and these are found in the Vienna Convention. This is also considered customary international law. So it's binding on all states when they're interpreting what they're committed to under a treaty. And it requires treaties to be understood in context and in light of other relevant law, like human rights. So for example, human rights law is included in the preamble of the Paris Agreement. And the preamble itself does not create legally binding obligations, but it can help out meaning to the treaty's terms, and it's part of its interpretive context under the BCLT. In Article 7 of the Paris Agreement, its dedicated article on adaptation recognizes the importance of adaptation in long-term global responses to, quote, protect people, livelihoods, and ecosystems. Now, this text brings adaptation in line with the protective purposes of human rights law, and it emphasizes the importance of longer-term thinking. So in brief, I'm going to shorten this, but this helps establish the relevance as required under this term, the VCLT, and the role of human rights in interpretation to support a reading of obligations that require states to integrate human rights law in their understanding of these obligations on adaptation, and in particular to integrate core positive duties associated with human rights, which requires them to ensure minimum essential levels of each right, so adequate food, water, housing, and health. What this means is that this requires climate action that's proactive when risks to rights are foreseeable, not only when they are imminent or when they have already caused damage. This shift in timing, which I'm arguing for, has been highlighted in decisions and commentary of human rights bodies as well. So, for example, the Human Rights Committee has highlighted that anticipatory action and adaptation planning is a means to meet human rights obligations in the Tessiada and New Zealand case, which had to do with refugee issues. And it underscored the importance of timely adaptation action in preventing foreseeable violations of human rights in the Billy and Australia decision. Now, the second interpretive move I make is to include the operative principles of the climate regime in interpreting climate obligations. And these are set out in Article 3 of the UNFCCC, and they include principles of precaution, equity, and we've heard a bit about this, the common but differentiated responsibilities and respective capabilities. Now, these principles can further guide and shape the timing and nature of adaptation support and adaptation itself. And equity and differentiation in particular are critical to assistance and cooperation obligations to clarify who is due support and who must provide it. And this is where I think there's some important overlaps between demands for reparations and my arguments for adaptation, because both require that developed countries like Australia support vulnerable developing countries in their adaptation efforts. Now, what does this interpretive approach mean concretely for Australia and its international adaptation obligations? First, for obligations to act on adaptation, it would require that Australia take adaptive action when climate change poses foreseeable risks to people, to their access to essential food, potable water, basic housing, and healthcare. But it doesn't mean that specific action will be required in every circumstances. There are multiple ways to meet these obligations. It can be through changes to infrastructure, to land and agricultural policies or plans, or even to the outright provision of resources, which has been ordered in some cases. It can also, though, include planning for and ensuring safe, dignified pathways for movement when these measures are no longer sufficient. And this is a key point of understanding for me that incorporates precaution and human rights in a way that can help shape the timing and nature of domestic adaptation to better ensure that measures are taken before people are unable to access their rights and resources and before they're displaced. Second, meeting adaptation obligations of assistance and cooperation requires developing countries like Australia to support vulnerable countries in their adaptation efforts. And so at a minimum from these obligations, it means that they have to, this translates into financial support, but it could amount to a wide range of other measures, including facilitating transfers of remittances, assistance with securing land elsewhere, legal pathways to migrate, and technological and technical support. But it's important the support must not be a one-off, and it can't dictate the outcome. Not all countries and communities are responding to risks and climate events in the same way. And there are different perceptions of the prospects of and utility of mobility across communities. My research within the region more broadly points out to some of these tensions between choosing to stay somewhere and then planning to move, which ultimately should be a decision of those that are affected by climate impacts and the communities that are facing a movement. So far, I've offered one way to use existing legal structures to argue for states to take action that is anticipatory, so taken before the worst harms occur, which can facilitate both in situ or in place adaptation and adaptive mobility, as I call it. This approach can help people move beyond these ad hoc and responsive measures that often happen after significant harm and damage, and it can help mitigate or avoid foreseeable risks to people and their rights. But is that enough to align in some ways with demands for climate reparations? Can I situate these arguments within or alongside such demands? And my instinct is to consider the ways these arguments for adaptation and mobility are both in tension with and aligned with the demands for reparations. And this raises a few conceptual distinctions to grapple with, which have already been raised today. The first is between reparations and losses damage, for example, where the discussions of mobility most often reside in the climate regime, which is in the loss and damage area. And then adaptation and reparations, both are premised on addressing some degree of unavoidable damage that has occurred, is occurring, or is anticipated. But adaptation itself can also be a form of reparation. So in the Billy case I've already mentioned, for example, the Human Rights Committee called on Australia to make full reparations. And in addition to adequate compensation, this included community consultation and the continued adaptation measures that would enable Torres Strait Islanders to safely stay in their homes and not be forced to move. Within the climate regime, the overlap between work streams is clear in some ways. More mitigation means less loss and damage and need for adaptation. And adaptation, as I mentioned, is a form of addressing loss and damage, including through measures on migration and through the work of the Task Force on Displacement. But what of financing that we've already heard a lot about? What about meeting adaptation obligations of support? Will contributions to the Loss and Damage Fund be considered separate from required adaptation finance, or will be another form of double dipping, right? Will this be financial commitments that come at the expense of one another? There are also normative alignments and tensions between more anticipatory approaches to adaptation that I think can interact with larger projects of reparations. Both respond to, I think, inequitable impacts of climate change and can lead to similar ends. So for example, arguments for migration as reparation and adaptive mobility, as I've set out, center community-led processes and choice about where and whether to move. More can also be done to emphasize that collective right on self-determination, and more generally, the inclusion, I think, of transformative adaptation, which is continuing to be pushed, can align with reparative aims that Rachel mentioned today. And I think also incorporating principles of equity and differentiated responsibility as called for in the climate treaties also provides an additional basis to potentially highlight the historical causes of climate harm and vulnerability. But as I've noted from the outset, arguments for migration as reparation often eschew legal frameworks in favor of moral and ethical legal obligations. So then, can strong legal claims for adaptation bolster these kinds of non-legal obligations? So if adaptation obligations are met and we can scale up support, I think this can be a step towards more just outcomes. To flesh out the content of international obligations can support calls for action from Australia and other high-emitting countries. But by relying on adaptation obligations, I'm making a tactical decision, not to deny that international legal systems have not been complicit in perpetuating injustices, because they certainly have, but rather they can still be used as a tool to a functional ends. And finally, I think there are a few temporal distinctions I want to highlight. At a superficial level, reparations or remedial processes seek to address damage to harm that has already occurred, in contrast with adaptation that requires action now to mitigate, in part, harm going forward, without necessarily needing to establish the causes of that past harm. But the interpretive approach I've highlighted is a bit of both. It takes past harm into account in understanding vulnerability. And I'm making a similar argument for adaptation as for loss and damage that Jeremy made. To incorporate these social and political conditions into adaptation action to address vulnerability. And in this way, I think it ties in a long history of environmental justice in practice and better enables us to prioritize the forms of action and support that should be targeted first. In doing so, I think this approach can shape action that's both anticipatory and that necessarily addresses the factors from the past. This approach has allowed me to deliberately reframe climate mobility to both draw on international law as part of the wider discussions of solutions to address climate change, and then also to demand cooperative action before people are forced to move. Such a demand is aligned with the more general need for collective anticipatory action that extends beyond mobility and can better shift the focus from the individual migrant back to the causes and consequences of climate change.